The school enrollment paperwork arrived in my mailbox on a Tuesday afternoon, addressed to Mr. and Mrs. Peterson regarding our daughter Emma's registration for third grade. I stared at the envelope for several seconds, confused by the error. Our last name was Mitchell, not Peterson. Emma Mitchell, age 8, had been enrolled at Lincoln Elementary since kindergarten under that name. I assumed the school had mixed up our mail with another family's documents. Inside, however, was Emma's completed enrollment form in my wife Sarah's handwriting, clearly listing our daughter as Emma Peterson, with Sarah Peterson listed as the mother and father unknown, marked in the paternal information section. Sarah had changed Emma's surname to match her maiden name and effectively erased me from our daughter's school records, all without my knowledge or consent. My hands trembled slightly as I processed what I was seeing. We weren't divorced. We were still married, living in the same house, co-parenting Emma together. Yet somehow, my wife had managed to alter our child's legal name and educational records as if I didn't exist. I sat in my car outside our house for 20 minutes, forcing myself to remain calm while my mind raced through the implications. This wasn't an administrative error or miscommunication. This was deliberate deception that potentially violated multiple laws regarding parental rights, identity fraud, and court-ordered custody arrangements. Sarah had no idea that I had been quietly documenting her increasingly erratic behavior for the past 6 months, following advice from my attorney during our preliminary divorce discussions. She also couldn't know that her secret name change had just provided me with the evidence I needed to fundamentally alter our custody arrangement. As I walked through our front door that evening, briefcase containing copies of the enrollment papers, I decided not to confront Sarah immediately. Instead, I would let her believe her deception was successful while I prepared a legal response that would demonstrate exactly why the family court system exists to protect children from parental misconduct. My name is David Mitchell, 35 years old, software engineer at Meridian Technologies, where I've worked for the past 8 years developing enterprise security systems. My professional background in data protection and digital forensics has taught me the importance of documentation, evidence preservation, and systematic problem-solving, skills that would prove invaluable in protecting my daughter's interests. During the most challenging period of my life, I met Sarah Peterson 7 years ago at a community fundraising event. She was 28, working as a marketing coordinator for a local nonprofit, with an engaging personality and apparent commitment to family values that attracted me immediately. Our relationship progressed naturally through dating, cohabitation, and marriage after 2 years together. Emma was born 18 months after our wedding, and for the first 5 years, we functioned as what appeared to be a stable, loving family unit. The early signs of instability in our marriage were subtle but persistent. Sarah had always been somewhat controlling about household decisions, but this tendency intensified after Emma's birth. She began making unilateral choices about child care, education, and social activities without consulting me, then presenting them as decisions we had made together. When I questioned these patterns, Sarah would become defensive, claiming I was being unsupportive or didn't trust her judgment as a mother. More concerning was Sarah's increasing tendency to present different versions of events to different people. She would tell her family one story about our financial situation, tell my parents something contradictory, and maintain yet another narrative with Emma's teachers or our neighbors. These inconsistencies weren't necessarily malicious initially, but they created confusion and occasional embarrassment when the contradictions became apparent. The relationship reached a crisis point 8 months ago when I discovered that Sarah had been intercepting and hiding bills, including several overdue notices for credit cards I didn't know existed. When confronted, she initially denied the accounts existed, then claimed they were for household emergencies, and finally accused me of being financially controlling when I requested access to all our financial records. This discovery prompted me to consult with Patricia Williams, a family law attorney specializing in custody cases involving parental misconduct. Patricia's initial advice was direct: begin documenting everything immediately, separate our finances where possible, and prepare for the possibility that Sarah's deceptive behavior might escalate if she felt threatened by potential divorce proceedings. Based on what you're describing, Patricia explained, your wife exhibits patterns of deception and unilateral decision-making that could impact custody arrangements. Courts take very seriously any actions that undermine the parental rights of the other spouse. Following Patricia's guidance, I began maintaining detailed records of Sarah's behavior patterns, financial decisions, and any instances where she made unilateral choices about Emma's welfare. I also started saving copies of all communications, taking photographs of important documents, and maintaining a secure digital archive of evidence that might become relevant in custody proceedings. 6 months ago, I formally separated our finances, establishing individual accounts and carefully documenting our shared expenses related to Emma's care. I also began recording conversations when possible within the legal boundaries of our state's single-party consent laws. Sarah interpreted these changes as signs of impending divorce and became increasingly secretive about her own activities and plans. The pattern escalated when Sarah began making significant decisions about Emma's life without discussing them with me. She enrolled Emma in expensive after-school programs without consultation, changed Emma's pediatrician to a doctor I had never met, and began taking Emma to therapy sessions that she claimed were for adjustment issues related to our marital tension. When I requested information about these therapy sessions, Sarah refused to provide details, claiming doctor-patient confidentiality prevented her from sharing information. When I contacted the therapist's office directly, I learned that Sarah had represented herself as Emma's sole legal guardian and had requested that I not be given any information about the sessions. This misrepresentation of custody status was a significant red flag that prompted me to accelerate my legal preparations. Patricia advised filing for formal divorce and requesting temporary custody arrangements before Sarah's deceptive behavior could further escalate. What you're describing suggests someone who is systematically undermining your parental relationship, Patricia observed. The misrepresentation to medical providers is particularly concerning because it indicates willingness to deceive professionals about legal custody status. I had been preparing to file divorce papers when the school enrollment documents arrived, revealing that Sarah had taken her deception to an entirely new level. Changing Emma's last name without my knowledge or consent wasn't just morally questionable, it was potentially illegal and definitely grounds for emergency court intervention. That evening, I observed Sarah's behavior carefully as we went through our normal family routines. She seemed relaxed and confident, apparently believing that her secret was safe. During dinner, she mentioned enrolling Emma in some new programs for the fall without providing specific details. When Emma mentioned her new school, Sarah quickly redirected the conversation. After Emma went to bed, I retreated to my home office and called Patricia's emergency number, sending her photographs of the enrollment documents while we spoke. This is serious, Patricia confirmed after reviewing the paperwork. Changing a minor child's name without both parents' consent is illegal in our state. Misrepresenting custody status to educational institutions is fraud. We need to file for emergency relief immediately. We spent the next 2 hours developing a comprehensive legal strategy. Patricia would file for immediate emergency custody based on Sarah's fraudulent actions, request court-ordered restoration of Emma's correct legal name, and seek sanctions against Sarah for violations of parental rights. The documentation I had been gathering for months would support these requests by establishing a pattern of deceptive behavior. The name change gives us grounds for emergency action, Patricia explained. Courts take these situations very seriously because they often indicate parental alienation or flight risk. The judge will want to ensure Emma's stability and protection. Over the next 3 days, I maintained normal family routines while Patricia prepared our emergency filings. I continued documenting Sarah's behavior, noting that she seemed increasingly anxious and spent considerable time on private phone calls with people she didn't identify. On Friday afternoon, a process server arrived at our home with court documents. Sarah's shock and panic upon receiving the emergency custody petition were immediate and dramatic. She accused me of attacking the family and claimed that the name change was simply updating records to reflect her preference. "You had no right to change Emma's name without my consent," I said calmly when she demanded an explanation for my actions. "You also had no right to misrepresent our custody status to the school." "I'm her mother," Sarah replied defensively. "I was protecting her from confusion during our marital problems. By erasing me from her records and lying about legal custody? That's not protection, that's fraud." The emergency hearing was scheduled for the following Tuesday. Patricia advised me to maintain my normal parenting routine, continue documenting any concerning behavior, and avoid confrontational discussions with Sarah that might escalate tensions before court proceedings. Sarah's response was to retain Marcus Davidson, an aggressive family law attorney known for contentious custody battles. Davidson immediately filed counter motions claiming that I was being vindictive and that the name change was a minor administrative matter. Blown out of proportion by my desire to control the family, the hearing was held in Judge Patricia Shun's courtroom, with both attorneys presenting their positions regarding the emergency custody request. Davidson argued that the name change was within Sarah's rights as a parent making decisions about her child's welfare during marital difficulties. Patricia's presentation was systematic and devastating. She provided the court with comprehensive documentation of Sarah's deceptive behavior, the fraudulent name change, and the misrepresentation of custody status to multiple institutions. Most importantly, she demonstrated how these actions fit a pattern of undermining my parental relationship with Emma. "Your Honor," Patricia argued, "this case involves systematic deception designed to erode the father's legal and emotional relationship with his daughter. The name change wasn't an isolated incident but part of a broader pattern of fraudulent misrepresentation." Judge Chin's response was immediate and unequivocal. "I find the evidence of fraudulent name change and misrepresentation of custody status to be extremely concerning. These actions suggest a willingness to violate legal procedures and potentially endanger the child's relationship with both parents." The judge issued several orders that exceeded even what Patricia had requested: immediate restoration of Emma's legal name to Mitchell, emergency custody to me with supervised visitation for Sarah pending full evaluation, court-ordered psychological assessment for both parents, and appointment of a guardian ad litem to represent Emma's interests during proceedings. Most significantly, Judge Chin ordered Sarah to provide complete accounting of all decisions made regarding Emma's medical care, education, and activities over the past year, along with explanation of any misrepresentations made to institutions about custody status. "The court will not tolerate fraudulent actions that undermine parental rights," Judge Chun stated firmly. "Ms. Peterson's conduct raises serious questions about her judgment and respect for legal procedures. That must be thoroughly evaluated before normal custody arrangements can resume." Sarah's reaction to the court's orders was a combination of shock and rage. She accused me of destroying the family and claimed that Judge Chun was biased against mothers. Davidson advised her to comply fully with court orders while they prepared for the full custody hearing scheduled 6 weeks later. The guardian ad litem, Dr. Rebecca Martinez, began her evaluation immediately. Her interviews with Emma, both parents, and relevant professionals revealed the extent of damage Sarah's deceptions had caused. Emma was confused about her name, uncertain about family relationships, and had been receiving conflicting information about our family situation. "Emma has been placed in an impossible position," Dr. Martinez reported to the court. "She's been told different stories by different adults about basic facts regarding her identity and family structure. This confusion is harmful to her emotional development and sense of security." The psychological evaluations were equally revealing. My assessment showed normal parenting capabilities with appropriate concern for Emma's welfare. Sarah's evaluation raised concerns about impulse control, respect for boundaries, and tendency toward deceptive behavior when frustrated. During the 6-week period before the full hearing, Emma thrived under the structured custody arrangement. Her confusion about her identity began resolving as consistent information replaced the conflicting narratives she had been receiving. Her school performance improved, and her relationship with me strengthened without the interference Sarah had been creating. The final custody hearing was comprehensive, involving testimony from multiple witnesses, review of extensive documentation, and consideration of all professional evaluations. Davidson attempted to minimize Sarah's actions as mistakes made under stress, but the pattern of deception was too well documented to dismiss. Judge Chen's final ruling was decisive. I received primary physical custody of Emma, with Sarah granted supervised visitation that could potentially progress to unsupervised time based on her compliance with court-ordered therapy and parenting classes. Most importantly, the court issued permanent restraining orders preventing Sarah from making unilateral decisions about Emma's name, medical care, or education. The evidence demonstrates a systematic pattern of deception and disregard for the other parent's rights, Judge Chun explained in her ruling. While the court recognizes Ms. Peterson's love for her daughter, love alone is insufficient when accompanied by behavior that undermines the child's best interests and violates legal procedures. Sarah was also ordered to pay court costs and attorney fees related to the emergency proceedings, since her fraudulent actions had necessitated legal intervention to protect Emma's interests. The aftermath of the court proceedings brought unexpected clarity to our family situation. Sarah eventually began complying with court orders, attending therapy, and working toward rebuilding a healthy relationship with Emma within appropriate boundaries. The structure imposed by court oversight eliminated the chaos and deception that had characterized our previous family dynamics. Emma adjusted well to the new custody arrangement, particularly benefiting from the consistent information and stable expectations that replaced the confusion she had been experiencing. Her therapy sessions, now conducted with my full knowledge and participation, helped her process the difficult transition while maintaining love for both parents. 6 months after the final hearing, Sarah had progressed to unsupervised visitation and was demonstrating better respect for boundaries and legal procedures. Our co-parenting relationship, while never friendly, became functional and focused on Emma's needs rather than adult conflicts. 1 year later, Emma was thriving academically and emotionally, with a clear understanding of her identity and family structure. The fraudulent name change that had triggered the legal crisis became, ironically, the catalyst for establishing the stable environment Emma needed to flourish. Looking back on the experience, I recognized that Sarah's secret name change was symptomatic of deeper issues in her approach to relationships and authority. The court's response wasn't just about correcting a fraudulent action, but about establishing clear boundaries and accountability that benefited everyone, including Sarah herself. My wife secretly changed our child's last name. She didn't expect the court's response to reveal the full extent of her deceptive behavior and result in a custody arrangement that prioritized our daughter's stability over adult preferences. The legal system worked exactly as intended, protecting a child's interests. When parental behavior threatened her welfare and identity, the most valuable outcome wasn't winning a custody battle, but creating an environment where Emma could develop her own sense of identity without manipulation or confusion. Today, as we navigate the ongoing challenges of co-parenting, the court-imposed structure continues to serve as a foundation for putting Emma's needs first. Regardless of adult emotions or conflicts, the experience taught me that protecting children sometimes requires uncomfortable legal interventions, that documentation and evidence matter more than emotional appeals, and that courts can be effective advocates for children when parents lose sight of their responsibilities. Most importantly, it reinforced that a parent's primary obligation is ensuring their child's stability and security, even when that means accepting consequences for poor decisions.